For delivery of judgment, matter pertaining to Kohima bench. For judgment, WPC 57/2026 with 2 eyes.
The petition is dismissed. The court is inclined to direct as follows. The authorities shall give a reasonable time to the petitioner to move to his place of posting. However, it will be open to the respondent authorities to allow the relieving officer to take over charge on and from such date and time as will be deemed fit by the authorities. In the event the petitioner does not hand over the charge to the relieving officer, the competent authorities are permitted to allow the relieving officer to unilaterally using charge of court. Therefore, party with the record, it is reiterated that the relieving officer has expressed her apprehension before the court that as she has come on transfer and could not take over charge, her future career will be adversely affected. In this regard, the court cannot perceive that a career or any officer of the armed forces would be impacted in future due to the interim order dated 24/4/2026 after this court. If that is done, the relieving officer is at liberty to approach this court.
Please, your lordships, if your lordships, I had a small request to make, your lordship. The judgment could be marked not reportable, your lordships. It's later used by other personnel to, if it could be marked not reportable, your lordships. Only that request, please, your lordship.
Next is lordship. Yes.
There are about 5 items at the top of the list. May I request that, my lord, my item number 22 may be upgraded, my lord, after top of the list, my lord, my matter.
So there are motion matters before that we can't upgrade.
Then after motion, my lord. After motion, my lord, because execution is going on. Obligation.
So I beg to mention item number 53 of the lordship daily list, my lord. 53, my lord. There, my lord, the appellant had expired, and I had filed a petition for, my lord, substitution, but that is not listed. Perhaps says that defects, my lord. I'll go and see it, my lord. Rectify that, and it will be taken up after 1 week, my lord. You have informed the other side? I have informed the other side. Mr. Upadhyay appears, my lord. I have spoken to him. Consent of the other side. Mr. G. Chaudhary, I have counsel for the petitioner, please put it on. It is submitted that the appellant had died. Appellant has died, and an application for substitution has been filed. However, his name is not listed. Please for some time to find out if there is any defect. Next, the registry shall examine the matter, and if there is no defect in the application will be dispelled and the others.
On diplomat, may appear. In item number 41, your lordship, there is some emergency. May kindly be updated, your lordship. Because there is no stay on the interim judgment and decree, and if the decree is executed, you suffer.
Make please, your lord. May I be permitted to check the case record of item number 38 for all?
May I please, I beg to mention item number 5, my lord. I am paying adjournment for that day, my lord. And arguing concern is annual for today, my lord. Obliged, my lord.
May please, your lordship, I beg to mention item number 8 from the daily list. Motion method, there is some difficulty on our part. If the honorable court allows, it may be listed on 29th.
May please, your lordship, I would like to mention item number 31. Lordship, my conducting counsel, Mr. S.K. Poddar, could not come due to some personal inconvenience. So kindly grant us 2 weeks of time. Yes, Lordship. DRMM 31. Authorized.
Top of the list, item 1 with item 2.
May please allow. My lord, in item number 1, my lord, my application for staying of the execution proceeding till disposal of another suit, my lord, and rejected against it and before your lordship. My lord, in this case, my lord, the order is at page 50, my lord, relevant portion is at page 53, my lord. It is clear from second paragraph. It is clear from the provision that the suit should be pending between the holder of the decree which is being executed by such court and the person against whom the decree is being executed. However, counsel for the third party petitioner has relied on 1999, wherein it states that the execution of the decree can be stayed in pending suit between decree holder and third party. It is my considered opinion that when the provision is clear, I not deemed it necessary to rely upon the submission of the counsel of third party petitioner. Moreover, counsel has not provided the name of the relevant case law or the case law itself, and only a photocopy of the page is given, and therefore I fail to consider the same or the fact of the present case, and the same there is only a part. My lord. Application is at page, my lord, 37. 37. My lord, page 13. Shankarlal Bharuka is my lord. Shankarlal Bharuka is the son of the original tenant. Original tenant was my lord, Bangshidhar Bharuka, his father. And the proforma opposite and the proforma mother and the opposite party number my lord. 2, 3, and 4, my lord. They are my step brother, my lord. My lord. I understand from the first quote of the original tenant. My lord. It is at page 29, my lord. My lord. That is not. My, well, they were using the tenancy on behalf of me. And after that, without making me party, I. The learned trial court has
Hello, they brought up to High Court. But yes, yes, yes. Well,
And my lord, learned trial court has rejected my petition on the ground that I am not a party to the decree. So this provision does not, order 21, rule 29 does not apply. My lord, so my lord, my ground is that my lord, this petition could have been treated as a party by third party. Could have been, the provision is wrong, my lord, that I have to admit.
so they fought up to High Court, man. The civil division is there. I have given a copy of the civil division. This honorable court. That went up to this High Court, man. And here, my lord, they have paid for 6 months' time, my lord, and they were granted 6 months' time to vacate the. They have to give undertaking. My lord, he passed on. He has established in Jagi Road long back, and he has business at Gauhati and Jagi Road. Well, actually, Supreme Court in matters, my lord, has initiated contempt also. Contempt also, my lord. That they are not in the decree. I can place one judgment, my lord, that's a 15, 14, 16, 694. Plus, if you just see, my lord, how paragraph 9 to 13. My lord. Many judgments, earlier judgments. Nine to 13, my lord, paragraph, we have also received earlier judgments. In this present judgment, my lord, yes. CRP. Oh, CRP last, my lord, paragraph, that the undertaking has been given, my lord. That paragraph 16. they did not submit undertaking also, my lord. the erstwhile landlord. And upon purchase, the respondent number one informed the said tenant of the purchase, requiring payment of rent to the plaintiff, to the said respondent number one. Full stop. It was projected that the rent of the tenanted premises was collected by the husband of the respondent number one to his staff from the tenant at the rate of rupees 325 per month, payable within first week of every calendar month. Full stop. It would suffice to mention that after discussing 9 issues which arose for decision in the said TS 361 of 2011, the tenants were held to be defaulter and the suit was decreed with cost by holding that the defendants were liable to pay rent and to be evicted from the suit premises, directing the area rent of rupees 3,575 and to be due and realizable, and to pay rupees 325 per month during the pendency of the suit and cost of the suit. Full stop. At this juncture, the learned senior counsel for the respondent number one has produced a copy of the order dated 31/10/2019 passed by this court in CRP 56 of 2019 to project that against the judgment and decree dated 1/2/2019, the respondent, the original defendants in the said TS 361 of 2011 had preferred a regular first appeal before the court of learned civil judge Dhubri, second bracket, now civil judge within bracket, senior division bracket was Dhubri. Full stop. The appeal was allowed. The appeal was allowed. First appeal was allowed, and thereafter the respondent number one approached this court under section 115 of the CPC, which was registered as CRP 56 of 2019. First of the learned first appellate court, this court by an order dated 31/10/2019 allowed the revision and set aside the first appellate judgment and decree. Full stop. The observations of this court, paragraph 16 of the order dated 31/10/2019 passed in CRP 56 of 2019 is extracted below. Next paragraph. Thereafter, the petitioner, being a third party, had filed TS1 of 2020 before the Court of Learned Civil Judge, Dhubri, for declaration and permanent injunction, as stated above, claiming 1/4 share in the business of Messrs. Baruka Trading. Huh? I'm there, page 30. Oh, so there are two business, Mahavir Stores as well as Baruka Trading. Paragraph 2, this page 30, you are saying, first line, second line is Messrs. Mahavir Stores. And then the name changed to Baruka Trading. Claiming that it's okay, but the change of premises is there, the change of name is there, paragraph 2. So, it is claiming that the deceased Banshidhar Baruka was a tenant under Bhuvaneshwar Prasad Ram since 1970 and was operating business in the name and style of Messrs. Mahabir, M-A-H-A-B-I-R, Mahabir Stores. From the Suitland, and later on the name of the firm was changed to Messrs. Baruka, B-H-A-R-U-K, Trading. And the petitioner claimed to be the son from the first wife of his father and was residing in the suit premises and carrying out business along with his father. It was projected that the suit was collusive and only filed against against Pushpa Devi Baruka and respondent numbers 2, 3, and 4 without disclosing the name of the petitioner, was also one of the son of Banshidhar Agarwala. So it is stated that the said defendants played a fraud to deprive the petitioner from getting share in the suit property. So it was also projected that the defendant numbers 2 to 4 in TS1 of 20, the defendants respondent numbers 2 to 4 always made false statements regarding the status of the suit premises. So accordingly claiming right to the suit premises as well as business to the extent of 1/4 share of the suit premises and business of Messrs. Baruka Trading, the suit for declaration and permanent injunction was filed for a decree that the defendant respondent numbers 2, 3, and 4 with bad intention to deprive the petitioner plaintiff had not stated anything about the right share of the plaintiff in the suit premises and the business of Messrs. Bharuka Trading, and thereby played fraud. So before that, it will be just write as the A. The suit be decreed declaring that that late Banshidhar Bharuka alias Agarwala was the tenant of the suit premises under Bhubaneswar Prasad Ram since 1970. You'll copy it from page 34. ABCD. And next page, EFGH. Full stop. Next paragraph. Along with the suit, a separate application was filed under Order 21, Rule 29, read with Section 151 CPC. Praying for stay of the execution proceedings of TX number 2 of 2018, arising out of decree passed in title suit number 361 of 2011. Next paragraph. The respondent contested the proceeding by filing written objection, and the learned learned executing court by order dated 15/3/2023 passed in TX 2 of 2018 dismissed the said application. Next, the learned counsel for the petitioner had submitted that as the petitioner had claimed right title interest of the suit premises as well as in the business, which was a tenant, the petitioner would suffer irreparable loss and injury if the decree is executed and the suit being TS number 1 of 2020, which is subsequently re-registered as TS 23 of 2021, shall be frustrated. Is it right? It was 1 of 2020 and then renumbered as 23 of 2021. Frustrated. Full stop. Referring to the provisions of section 146 of the CPC, it is projected that the heads and legal representatives are entitled to make an application in the proceedings, though he was not a party to the suit. So it was also submitted that the finding of the learned executing court holding that the judgment debtors in TX number 2 of 2018 were running the business and were sufficiently represented is perverse. More so as it was not denied that the petitioner was the son of the original tenant and had a right to be in the suit premises. So it is also submitted that the petitioner was a necessary party in the execution proceedings. It is also submitted that although the application was filed under Order 21, Rule 29 of the CPC, but this court would have power to direct that the said application be treated as an objection by the objection to the execution by a third party, and the same be taken up for adjudication under Order 21, Rule 97 of the CPC. Next paragraph. The learned senior counsel for the petitioner has submitted that the interest of the petitioner was taken care of by the respondent numbers 2, 3, and 4, and Srimati Pushpa Devi. Bharuka, BHARUKA, and therefore the decree which was passed in TS number 361 of 2011 could not be registered by the petitioner. To stop. By referring to the case of Anil Kalra, Anil Kalra, KALRA versus JD Pandey and others, 2000, within bracket 2015, bracket post 16 SCC 694. It has been submitted that the tendency of obstruction to the decree by dubious ways has to be strongly repelled. Next paragraph. Mr. Saivala, anything else you wanted to say since I so it is further submitted that in paragraph 3 of the plaint of TS 23 of 2021, there is a categorical statement that the petitioner plaintiff lived with his father Banshidhar Agarwala in the suit premises and married in the year 1984, and thereafter left Dhubri for Silbhanga, Silbhanga, Chagi Road in Morrigaon district in the year 1988/89, and was then residing running business at Gauhati. So accordingly, it is submitted that the petitioner had no interest in the suit premises or the business of the firm. Next paragraph. It is noticed that in paragraph 4 of the plaint of TS 23 of 2021, the following statement has been made by the petitioner, page 30, paragraph 4. Stop. Thus, there is a categorical admission that the business of Bharuka, Mrs. Bharuka enterprise was, Bharuka Trading was being operated by the respondent numbers 2 and 4. To stop. However, insofar as the further claim that the respondent numbers 2 to 4 were running the business on behalf of the petitioner is not supported by any document on record. If the business is being run on behalf of someone, the said third party would have his name either in the trade license or in the sale tax oblique GST oblique CGST records And naturally, the source of income would also be reflected in the income tax records. Full stop. However, in the plaint, there is no statement to show how the petitioner has interest in the suit premises, save and except oral statement to the effect that he has interest and 1/4 share in the business which is being operated in the suit premises. Full stop. In this regard, the learned executing court had clearly recorded that the petitioner had stated that the judgment debtors have been running the business on his behalf, and therefore it clearly shows that the petitioner was adequately represented by the other judgment debtors. Full stop. The said finding cannot be held to be perverse or inconsistent with the materials available on record. Next para. The materials available on record. No, sorry. From the copy of order dated 31/10/2019, passed by this court in CRP 56 of 2019, which is the revision filed against the first appellate judgment, where the decree passed in TS 361 of 2011 was contested. The court takes notice of the fact that by the said order dated 31/10/2019, the first appellate judgment was set aside, and therefore the decree passed by the learned trial court was revived. Full stop. By the said order, this court granted 6 months time to the judgment debtors in the decree passed in TS 361 of 2011 to vacate the suit premises. Full stop. Therefore, the suit being originally filed as TS number 1 of 2020 and subsequently re-registered as TS 23 of 2021 appears from Annexure 2 to this application that the same was filed on 20/12/2019. And from the seal of the Court of Learned Civil Judge, Dhubri, it appears that the registration of the suit was on 2/1/2020. Therefore, the suit is clearly filed to frustrate the decree that has been passed in TS number 361 of 2011, and with no document on record to show how the petitioner had interest either in the suit premises as a co-tenant or as the sharer in the business of a business that is being operated by the respondent numbers 2, 3, and 4 from the suit premises. Full stop. In the plaint of TS 23 of 2021, as well as in the petition number 269 dated 13/2/2020, which was filed by the petitioner in the execution proceedings of TX number 2 of 2018. There is no statement that the petitioner had ever tendered any rent to the respondent number 1. Full stop. Thus, the absence of any statement creating tenancy and in absence of any document which demonstrate that the petitioner has any interest whatsoever on the suit premises or the business running therefrom, the court does not find any infirmity or perversity in the order dated 15/3/2023 passed by the learned Monsieur number 1, Dhubri in TX number 2 of 2018. Next paragraph. In the considered opinion of the court, as the petitioner had filed a suit alleging fraud in the obtaining of decree in TS 361 of 2011, and has opted for the said suit and has filed an objection in the execution petition under Order 21, Rule 26. The submission of the learned counsel for the petitioner that the objection be treated as be directed to be treated as an objection under Order 21, Rule 97, cannot be exceeded to, as it would be as that would be within the sole discretion of the petitioner to do the needful before the learned executing court. To stop. As per the procedure prescribed under prescribed under Order 21, Rule 101 of the CPC, questions that can be determined under Order 21, Rule 97 shall be determined by the court in the application and not by a separate suit. Therefore, it would be within the discretion of the petitioner to elect as to whether they would proceed with the suit or file or contest the execution proceeding. Stop. In this case, the application for stay was moved under Order 21, Rule 29, which permits applications to be filed for stay of the execution pending suit between the decree holder and the judgment debtor. Stop. The petitioner claimed to have an interest in the suit premises and therefore would step and therefore claimed interest in the suit premises and the business standing therefrom, and therefore it is not open to the court to pass any order on the oral prayer made by the learned counsel for the petitioner. Direct the, to issue any direction to the learned executing court to treat the objection of the petitioner as one under Order 21, Rule 97 of the CPC. It would be in the discretion of the petitioner to do the needful as he may be so advised. Next paragraph. As this court is in session only in respect of the order dated in respect of challenge to the order dated 15/3/2023, the determination would be limited to only the nature to the said impugn order. Next paragraph. In view of the discussions above, this revision fails and the same is dismissed. Next paragraph. The interim order which was passed by this court by order dated 25/4/2023, it stands vacated. Next paragraph. Application is dismissed, no orders to post. Next paragraph, both sides are represented, they are direct through their learned counsel, both sides are directed to appear before the to appear in the proceedings of TX number 2018, pending before the court of learned civil judge within bracket junior division, that was Dhuri, on or before on 12/6/2026, and by producing a certified copy of the order, await for further orders to be passed on the said by the said learned court. And what is the second order, the second CRP? Page 26. Mr. Sayora, are you seriously objecting to it? Are you seriously objecting to the substitution? No, this is not a comment on the merit. If they are parties, let them be impleaded. Who are the legal representatives? 3 and 4 are son. No, whom do you want to substitute? Where are the names? Hmm? One, two, 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 three. There was no abatement. There was no abatement. Only what you call only substitution. Only substitution. He's saying 52 days. 52 days would be within 60 days. Within 90 days of abatement. Yes. No, no, no. Whether the arithmetic is correct. If the arithmetic is correct, then I think you'll have to file an appeal under Order 43 Rule 1R. No, not 1R. It is. I'm sorry. K. An order under 9 of Rule 22 refusing to set aside the abatement or dismissal of a suit. Order 43. Please check up. It is your. Okay. You have the CBC with you? CBC, give a CBC to Mr. Saibara. Yes. So this does not help you, this observation of the Supreme Court does not help you. The reason is that's why I'm asking you that whether this arithmetic is right or wrong. If it is 52 days beyond the period of limitation, limitation comes only when there is an abatement. And then 60 plus 90 plus 60 is 120, 120 plus 52. So 200 192 days in, you have filed the application 192 days, whether that arithmetic is correct. So what is the date of death? 14/1/24. And the application filed on 6/6/2024. So obviously there is a delay of almost 6 months, 180 days. So it crosses your 90 plus 60. Then it would just check up 1K would be again appeal. Out of 43 to 1K. You got it? Mr. Saiwala, you have read the provision. So revision would not lie. So to delegate you to file a first appeal, and this period undergone till now would be an application before the court which does not have jurisdiction. So you get the extension of limitation under section 14. We save you from that. It is Mr. K.K. Neelan, counsel for the petitioner, and Mr. G.N. Savala, and senior counsel, assisted by Ms. K. Bhattacharjee, and counsel for respondent number 1. As per the service report, as per the office note, the neither ID card nor unserved notice on respondent numbers 2 within bracket Roman 2, 3 and 4 have not been received, but as per office note dated 7/1/2026, AD card has been returned in respect of respondent numbers 2 within bracket 3 with signature of respondent 2 within bracket 1. So accordingly, the notice is duly served on respondent numbers 2/1 and 2/3. So none appears on call for these said respondents. Next, in order, in view of the order which is proposed to be passed, the issuance of fresh notice on the said respondents is not deemed necessary. Next, the respondent number 2 in TS 23 of 2021 and died on 14/1/2024. So therefore, 90 days time up to up to up to 24/3/2024 was available for substitution forty-one 43/2021 was available substitution, and for the 60 days time till 13/5/2021 was available for setting aside abatement. But the application for substitution was filed on 6/6/2024. So therefore, an application for setting aside abatement was abatement and substitution and condonation of delay was filed by the petitioner. Full stop. The Lared trial court by the impugn order dated 18/1/2025, rejected the application. Full stop. Therefore, as the rejection of the condemnation application had entailed the application for setting aside abatement to be rejected, such the impugn order would be subject to an appeal under Order 41, Rule 43, Rule 1K of the CPC. Full stop. Next, by the learned counsel for the petitioner has cited the case of Om Prakash Gupta, alias Lalua, LALLOWA, and within bracket since deceased, and others versus Satish Chandra, within bracket since deceased, 2025, SCC online, SC 291. Paragraph 11 on which Reliance stays. Does not appear to come to the aid of the petitioner, as the application for abatement, the setting aside abatement was filed after 150 days from the date of death. Next, be that as it may, as an appeal would lie against the impugned order dated 18/1/2025, the court is inclined to close this application by relegating the petitioner to approach the first appellate court having jurisdiction. Next para. This application was filed on 7/4/2025 and is being disposed of when order passed today. For the period between 7/4/2025 till the date of this order shall be considered by the concerned first appellate court to be proceeding bona fide proceeding which had continued bona fide in before this court, but without jurisdiction. As provided for under section 14 of the Limitation Act. So accordingly, however, I'm missing something. Should I close it or I return it back? Close it is okay. No. So we close it just. Close it. So therefore, comma. In the first part, sworn to till the date of the order, and an additional time of 30 days to close the first appellate court shall stand excluded. Your citations you can take it back. Just take it after some time. Let the secretary.
Top of the list, item 3.
You are saying that the decree has been executed. Your name? That is D. Bora, learned counsel, who appears on behalf of Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. S. Count, learned counsel appearing for the respondents. Respondent numbers 135678. None appears on call for the other respondents. Respondent numbers 2 and 4. Whatever it appears from the note sheet dated 21/5/2026 that petitioner has not taken steps for implement of the legal representatives of respondent numbers 2 and 4. It not appears for them. Next paragraph. Be that as it may, the learned counsel for the petitioner, upon instructions has submitted that in the meantime, the appeal has been filed against the judgment and decree dated 24/8/2023, passed in TS 72 of 2006. Next, the learned counsel for the appealing respondents has submitted that the same is correct and the appeal is registered in numbers as TA 22 of 2025, which is pending before the Court of Learned Civil Judge within bracket Senior Division bracket close Nagaon. He has also produced a certified copy of the order dated 28/2025, passed in TA 22 of 2025 by the learned civil judge within bracket Senior Division bracket close Nagaon, by which the said learned court had stayed the operation of the judgment and decree dated 24/8/2023 in exercise of power under Order 41 Rule 5 CPC. Next paragraph. In this, by filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 30/5/2024 as prayer for stay of the execution was rejected. Next, in view of the subsequent development, by order dated 28/2025, by which operation of the decree was stayed, the present application has become infructuous. And as the interim directions of the the interim orders order dated 28/2025, passed by the learned civil judge within bracket Senior Division bracket close Nagaon in TA 22 of 2025 shall hold the field. Accordingly, as this matter has become infructuous, this application stands closed. There shall be no orders to cost. You give us a photocopy, we'll keep this on record. The learned counsel for the respondents will provide a photocopy of the order dated 28/2025 to be retained on record. Give us a photocopy. G. Item 4.
For motion, item 4.
Where is your, you are Lucas Orang? You see, you made the court read the record, the file. We read the order, then we looked at all the documents. The trial court, the MSCT rejected your application because of the stand taken by the insurance in the objection. Very conveniently, this objection you have not filed here. We dismiss your petition on that ground. Don't do that. We are wasting time of the court. there are so many requests coming in by the learned counsel to upgrade their matters, to take it up. And then we are compelled to read these applications where you hide materials. And the court has given reasons why it has rejected. Then also you withhold documents. We dismiss it, you have to come, you come again, we give you liberty. But this is, we are dismissing. But Mr. R.S. Chauhan, learned counsel for the petitioner. No, we don't allow this applications by to come by affidavits. Why don't you see that your case is that there was one accident, then there are two claimants, two separate MACT cases have been filed. You say that you have filed the FIR and others reports of the other case, and the insurance takes an objection. While going through it, we don't find that objection. It's a wastage of time. Why should we encourage that? You file a new one. We are not acknowledge affidavits to come on record when we find that you are not producing everything on record. Mr. R.H. Chauhan, counsel for the petitioner, as the objection by the insurance company, which is referred to in the impugn order, has not been annexed, owing to suppression of material facts, important materials, the application stands rejected. Dismissed. However, with liberty to the petitioner to file a fresh application, if so desired, by producing all the relevant, annexing all the documents.
For motion, item 6.
As to whether the petitioners would inherit any share in the deceased estate of the deceased. Heard Mr. S. Das, learned counsel for the petitioner. By filing this application under Article 227 of the Constitution of India, comma, the petitioner has assailed the order dated. Which page is that order? But no order was passed. Not assailed. The petitioner projects that he had that they had presented an application for impediment of the sister-in-law of the deceased, comma, namely, comma, Hiran, Hiran, Hiran Bala Das, as opposite party number 4 in connection with MAC case number 2047 of 2018 before the learned member, comma, Motor Accident Claims Tribunal number 1, comma, Kamrup Metro, comma, Gauhati. However, the said learned tribunal had refused to accept the said application. Huh? Where is the date? In your petition, there is no date. You have a better copy. This we can't read. So it is not accepted. First of all, we stated that the said application was filed on 8/4/2023. 2023. 26. So however, the date appended at annexure 8 to this application cannot be read. Next paragraph. In the considered opinion of the court, comma, if any litigant files any application before any court or tribunal, including the Motor Accident Claims Tribunal number 1, Kamrup Metro, comma, Gauhati, for impleading of parties, comma, it was a duty cast on the said learned tribunal to entertain the application and to pass appropriate orders. Full stop. Non-acceptance of petitions would amount to jurisdictional error committed by the said learned tribunal. Full stop. The said act on part of the if such a thing has happened in the Motor Accident Claims Tribunal, number 1, Kamrup Metro, Gauhati, where the petition appended as Annexure 8 to this application was refused to be accepted, this calls for a this calls for a direction to the state of Assam to through the MSCT is under just give a scroll for government advocate. Okay. Give a scroll for government advocate, any government advocate. G Assam. Assam, especially the Commissioner Secretary of the Government of Assam, Transport Department, under whom the Motor Accident Claims Tribunals are functioning, to issue an appropriate administrative order so as to direct all the Motor Accident Claims Tribunals in the state of Assam not to refuse acceptance of any petition that any party intends to file. Full stop. Next, in fact, according to the procedural practice followed, all applications are to be filed before the bench assistant or superintendent of the concerned court. And it is the duty of the bench assistant to cancel the court fee stamps and to enter it in the petition register. There was no necessity at all for the learned member of Motor Accident Claims Tribunal, number 1, Kamrup Metro, Gauhati, to act as a peon in his own court to accept and to accept petitions filed by the litigants. The said conduct, if it has actually happened, is regrettable. Next para, accordingly, the court is inclined to direct the learned member, Motor Accident Claims Tribunal, Kamrup Metro, Gauhati, to accept the application proposed to be filed by the petitioner, namely Harish Das and another, in connection with the proceedings of motor accident MSC case number 2047 of 2018. Full stop. As and when the same may be presented. Next para. The said learned tribunal, on acceptance of the petition presented, shall inform the registry of the court about the compliance of this order. Full stop. Next para. In order to ensure ends of justice, this matter is kept pending so as to enable the learned counsel for the petitioner to report compliance. Next para. List on, give date after a month. Hmm? 14/7. That's the next para. As the next date is stated to be on 14/7/2026, the learned member, Motor Accident Claims Tribunal, Kamrup Metro, Gauhati, shall accept the petition filed before the date of filing, before the next date fixed. And it will be more permissible for the said learned tribunal to take up the application for consideration on the date fixed. That is my direction. Compliance to be sent to the register of the court. When is the date you said? 14/7. Your date after 14/7. Make it 20/2/07/2026. Asha, just before that you say, in the first order you say that pursuant to order dated 11/5/2026, the Learned Counsel for the petitioner has addressed the court regarding whether the petitioners would inherit any share in the estate of the deceased. Most of the in this regard, the Learned Counsel for the petitioner has submitted that as the family members of the deceased had all died, as per the judicial precedents of it was Supreme Court 2020, 2018, and 1987. The court is satisfied with the locus of the petitioners to make the application to maintain this application. We take these citations after some time. Let him type it out. Let the copy of this order be also sent to the Commissioner Secretary of the Government of Assam, Transport Department. Do be neutral in terms of the directions contained herein.
For motion, item 7.
You want to raise inconsistent plea, whether that is permissible. Where is your application? Is that the written statement is at page 40. Para number 3 and 5, this is inconsistent. Para number 4, Gauripur Town Committee is a necessary party. So it is barred under Assam Land Revenue Regulation, TP Act, etc. Additional 12 did not sell so and so land. But still your statements made here does not attract order 22 rule 4.2. Persons so made a party may make any defense appropriate to his character as legal representative of the deceased. So altering the written statement will not come within the meaning of appropriate to his character. No, but you are taking a different stand. Now you are taking a stand that the sale was by the was not by the Jivan Chandra, it was by some other in 81. Those plea are inconsistent. Oh, you are the plaintiff. You are aggrieved by this. Oh, I'm sorry. I was thinking you are a defendant. The petition was dismissed. Okay, okay. Mr. P.S. Dekha, Lanet Senior Counsel, assisted by Ms. B. learned counsel for the appellant, petitioners. Next para. In brief, the case of the petitioners is that on substitution of the legal representatives of the deceased defendants, the substituted defendant numbers 11 to 14 had taken contradictory plea in the written statement, which according to him is outside the scope of Order 42, Rule, Order 22, Rule 4 within bracket 2 of the CPC. Therefore, aggrieved by the order dated. Where is the order? Aggrieved by the order dated 16/2/2026, passed by the learned civil judge within bracket junior division bracket close number 5, Dhubri, by which petition number 1132/23, which is an application for striking out pleadings under Order 6, Rule 16 CPC. In TS 137 of 2021 was dismissed, the present, this application has been filed under Article 227 of the Constitution of India. Next, issue notice returnable on so give a date after 4 weeks. Returnable so petitioner shall take steps within 2 days for service of notice on the respondents by speed post with AD. Next para. Till the next returnable date, the further proceedings of TS number 137 of the 2021 pending before the Court of Learned Civil Judge within bracket Junior Division bracket close number 5, Dhubri, shall remain stayed. So before that, you said that the learned instructing counsel for the petitioners shall collect the postal receipt number and submit postal track report prior to the next date of listing. Okay. Three. Okay.
15 July. Supplementary item 49 for motion.
But again, this order 8 rule 1 applies. You took more than the required adjournment. You've seen that page 26. But where is your application that you have not received the copy? No, that is in the order. But where is your application that you have not been? Where is your petition 573? Where is that? Then we're not entertaining. No, that we don't know, but you see, why do you, what is the good thing in suppressing that petition? Mr. S. Daslan, counsel for the petitioner. Agreed by the order dated 25/3/2026, passed by the learned civil judge within bracket senior division bracket post Borpeta in TS 99/2025, by which prior to file written statement against counterclaim was rejected. The present application has been filed under Article 227 of the Constitution of India. Next, the learned counsel for the petitioner submitted that though petition number 573/2026, which is referred to in the order dated 25/3/2026, has not been annexed, but in paragraph 3 of the impugn order dated 25/3/2026, the learned trial court has recorded that while petition number 573/2026, learned counsel for the plaintiff had paid time to file written statement against counterclaim, showing cause that he did not know that the defendant had filed WS cum counterclaim, written statement cum counterclaim, and had not received copy of the written statement cum counterclaim till the said date. In view of the projection that the copy of written statement cum counterclaim was not served on the learned counsel for the petitioner plaintiff. David 227, the court is inclined to issue notice on this application under Article 227 of the Constitution of India, setting the order dated 25/3/2026. First of the notice is made returnable on so and so. The petitioner shall take steps within 2 days for service of notice on the respondents by speed post with AD. Next, till the as an interim measure until the next returnable date, the further proceedings of TS number 99/2025 pending before the Court of Learned Civil Judge within bracket senior division bracket post Borpeta in TS number 99/2025 shall stand stayed before that we also say we should notice the learned the registry shall call for the scanned copy of the written statement cum counterclaim, and the learned civil judge within bracket senior division bracket was Borpeta, while sending the scanned records, shall also scan and send the acknowledgement, if any, of service of filing of the copy of written statement come counterclaim in the record of title suit number 99 of the 2025. Accordingly, this order shall be brought to the notice of the learned civil judge, in bracket senior division, bracket was block it up.
July. Highly obliged.
For motion item 50.
Please, your lordship, matter may be passed over for the day.
For the day,
Lordship, for the day.
on the prayer made by the counsel for the petitioner, matters stands adjourned today. This on 29/5/2026. Admission need as an order 41. Conclude. না আমি তো অর্ডার স্বাগত লোক লাগে না
For orders item 23.
We are upgrading the orders first because otherwise the orders do not get touched. After that, we'll come to admission.
My lord, item 23,
Yes.
this case is ready as regards service, my lord.
Where is the impugn order against which you have come?
My lord, this is the second appeal, my lord.
You
Impugned
understand?
order is at page 91. Basically, it is a suit for partition has been filed.
And you claim that there was earlier a decree for
Earlier,
partition.
there was a partition by mutual partition.
The mutual partition
Yes,
was not a decree in the suit.
mutual partition is not a decree.
And you are claiming in this,
Basically, we are claiming for dismissal of the suit, my lord.
but that can't be accepted. The substantial question of law is,
We are the defendant in the suit, my lord.
You are asking for the dismissal,
dismissal, because
but that can't be because the earlier, what you call, whatever has happened is in the, in a vichar. So that vichar will not have the effect of a decree. And therefore, if somebody is aggrieved, can definitely maintain the suit and the,
but at the same time, my lord, when the decree has been passed, the right of the parties of all the sharers has not been determined, my lord.
you see, this is a partition suit.
Partition suit,
In partition suit, there is no requirement. I don't know, you see, in a partition suit, after the preliminary decree is passed, the decree is sent to the commissioner to find out the shares.
for passing of the preliminary decree, share has to be ascertained.
No. The recent end of Supreme Court judgment says that is not required. There may be people who are unrepresented, so therefore it is for the commissioner to find out what are the shareholding, and then bring it on record, and then the decree would be final decree would be passed.
My lord, without determining the share, my lord, how much share who are entitled,
You see,
that much only for preliminary decree, but so far is subsequent part is, it is final decree, that is for
no,
meets and
but
bounds
you see, determination of shares.
share.
What would be wrong if we say that the parties just if the trial court says that on the basis of the pleadings and evidence, whatever discussion is required to be made, they discuss it and say that this 50 people are required to have a share. In your case, 203 people are there. So let us say 50 people are entitled to share, and therefore the commissioner will determine the shares to which they are entitled to.
So that
And then-
determination of share, how much share, how they are entitled, suppose I am entitled 1/4, they are entitled 2/4, that like that, my lord, that is. to be
Then what is what is the fun of saying, sending it to the commissioner to do it? You
Com-
see, if it is, if people are following following, for example, Mohammedan law, then there'll be shares which has to be determined, which has to have some arithmetic done.
Commissioner cannot determine the share, my lord.
What is wrong in it if we send it? What would be the illegality if it is sent? It cannot be sent, I understand your argument. But what is the illegality if we send it? For the commissioner to do that inquiry and to send it, and after the preliminary decree, what you call, final decree is made.
My
On the basis of
humble
share demand.
submission, for determination, my lord, commissioner has no power, my lord, for determination. So far is, my lord, after determination, they can do this, their
Where
work.
is that, the requirement of a final decree that all shares has to be determined? And the question is why we should not, the court should not start to say that these parties are there. You see what happens, for example, a Hindu family following Mitakshara. Mr. Ghosh, let us say there is a family following Mitakshara mode of Hindu law. Now, by the time the suit is filed and by the time it is decreed, not even a new son would be born. His son would have been married, and the man would have a grandson. Now, can every time this suit be reopened to find that no, this child is born, the effect is from the date of the birth, he gets a share in the family ancestral land, and therefore the share has to be every time added. By the time these additions are done, again there will be 3 children more born. A will have 2 children, B will have 3 children.
No, that part may not be required, but
Why?
so far is,
In Mitakshara,
Suppose-
the birth itself gives a right for a child to have a share in the ancestral property.
with respect to Mitakshara law.
Yes.
Yes, with respect to
So if
Mitakshara.
this is done, then there will be endless, for next 100 years, I
With
don't see
respect
us
to
to-
Mitakshara.
What is wrong? The commissioner will go and determine, have the arithmetic done. For example, in a Mohammedan law. Now, please tell me, with the change of family pattern, how many calculations would have to be done to find out the share? And in this, today in this courtroom, how many will be capable of doing it right now? If I give a problem,
My lord, kindly see the decree passed in this case, my lord.
I'm
Page-
just asking you, you see,
page
I
55.
will hear you, but I'm asking you a query. If in this courtroom, we give a problem of a sharer in the determination of shares in a Mohammedan family, please tell me in this courtroom, I don't know anyone's capability, I'm not assessing it. I'm just asking a query. Whom do you think would be more competent to do it right now? That calculation. It will take some arithmetic. We'll have to go through Mullah law and then do the arithmetic. Now, if you give that to me and ask me to do it, by the time I do it, I will go in retirement. Not that I want to avoid work, but we have so much otherwise pressure. So why this should not be sent out? If the court requirement of order 18 rule 4 is that the commissioner will take an affidavit, will hear cross-examine the witness in his presence, he will record it. Why not? This should be admitted. Now let us see what you want to say.
Page 55, my lord.
55.
55. In the result, suit is preliminary decree on contest with cost in favor of the plaintiff. It is decreed and ordered preliminary that the plaintiff have right title interest over schedule so-and-so land and consequently delivery of first possession after determining by meets and bounds through the district collector as per so-and-so. Only with respect to plaintiff's share has been determined. What about the other share?
Where is the plaint?
Plain at page 20, starts from page 29.
Now you see, in this, the list is given at page 31.
Page
Landed
31.
property so-and-so.
Yes.
Now with this list, please come to page please come to page 31.
Yes.
Now
I'm
this
in
is the
31.
buyer name, this Lalit Nath, Dilip Nath, Dhiren Nath. They have purchased,
The following
This-
in the list of the land purchased by three brothers,
correct,
Dhirendranath.
we are coming to it.
Yes,
First is Lalit, Dilip and Dhirendra.
yes.
Second is Lalit, Dilip and Dhirendra. Third is Dhirendra Singli. Fourth is Dilip Nath, Dhirendra Nath. Fourth, fifth, sixth, seven, 8, 9, 10, 11, 12, 13, 14 is both of them, Dilip Nath and Dhiren Nath. And then it is Dilip Nath purchasing Singli. Now the plaintiff in this case is Dhirendra Nath. Page 17.
Dhirendranath.
Dhirendra Nath's the legal representatives have done done it.
Yes.
Now in this sale deed, there are land which is jointly purchased. So the partition would be only against the co-owner who have purchased it. So Dilip Nath
Dhirendra and Dilip.
Dilip,
Dhirendra and Dilip.
correct. Now if between these two people there is shares determined,
That
then
share
the
has,
other will already get a share.
that share has not been determined. That is,
Mr.
Yeah.
Ghosh, to complicate things, there are many issues. But tell me if there is a partition to be done in two brothers.
Two
If one
brothers.
share is determined, the other share will already be determined. What is wrong in it? Partition between Dilip and Dhirendra.
my lord,
One share is determined, the other share will already be determined. You see, the preliminaries of the land and revenue regulation is that when there are 4 sharers, there will be 3 shares will be separated. One will already be there. So that arithmetic is not to be done. There are 2 people who want to divide 100 rupees. I take my share of 50 rupees. The other share of 50 rupees is already determined. Why will that exercise be done?
My lord, it may be fixed for hearing, my lord. Hindi mein.
No, we already had it.
But otherwise, my lord, from the record, my lord, from the scheduled land, which has been mentioned, my lord, it is very much clear that the share between these 2 brothers has not been determined, my lord.
But how you agree with us?
Because determination has not been done by the
Do that arithmetic and come back by evening at 4:30. We'll take it up. Do that calculation. You already have the determined land. There are sale deeds. There are 2 or 3 purchasers. If it is so simple arithmetic, please do it. Or you tell us in how much time you'll do that arithmetic and bring it to us.
My lord, Tuesday next week, my lord.
Next week we'll bring it. Okay. Choose a date. The calendar is in front of you. The Mr. S.K. Ghosh, land counsel for the petitioner, is permitted to make the calculation of the shares of various shares in this appeal and present the calculation to the court for its perusal. List on. Oh, we required your presence. No, not in this matter. You suggest a date, he'll take it. I just interact with Mrs. Burman. You see, papers in which item? Huh? 50. Huh. 50. Item 6. Item 6. Here you see what has happened is very disturbing. The claimant in a MSCT case wants to implead the sister-in-law of the deceased and presented a petition before the Motor Accident Claim Tribunal number 1, and it did not accept it. You see, as a court, the court is highly aggrieved with that attitude of presiding officer of any court, not to accept a petition. And that is why we have passed an order that this MSCT tribunals are under the transport department. So we have issued a direction to the head of the department would be who? The commissioner secretary or secretary? Commissioner secretary. Okay. So we are issuing a direction to the commissioners and secretary to issue a direction to all the MSCT tribunals that if petitions are filed, it will be accepted by the bench assistant or what you call the superintendent of the court.
After hearing papers for that.
No, not even that.
Yes.
The requirement, you see, as a lawyer, what do? You go to a court, give a petition to whom? To the bench assistant. So let that practice be prevail. The petition will be before the bench assistant or the what you call the superintendent. He will give it to the court. It is not otherwise. The court will ask why is this petition filed, then take a preliminary hearing, and then ask the bench assistant to receive it. So that has to change. We have passed a judicial order giving them to give a direction to all the tribunals to accept all petitions. You see, as a lawyer, today as a government advocate, you may not be aggrieved.
Yes.
But if you are appealing for a party and your court does not accept your petition, there will be 100 reasons to be aggrieved. And in a day, many things can change. Everybody cannot come to High Court, get a direction from the court and then go back, throw a petition to the tribunals and courts. So they are under the Supreme jurisdiction. No, but you see, there's a reason to send it. The Supreme jurisdiction we can exercise, but then we are passing orders only against the tribunal against which the matter is here. But if I give a direction to the state, then they issue a circular to all the tribunals. Everybody will come to know this is to be complied with. So we request you that the registry will send it, but we request you to send it to the head of the department by whatever name. We have kept it pending so that the next date they can report it to us. But as a court, it is very difficult to accept the proposition that the courts are not accepting petitions. As a lawyer, any lawyer may be aggrieved by that. It affects the practice, and especially in MSCT. In MSCT, there are other lawyers will come in that no, this lawyer he knows nothing. Give the brief to me, I will do it. These things happen in the MSCT. So we are more concerned with that. So we know that is why one thing we have got it and one thing we want to check it. We understand, you don't have to say that we know it, but we don't get an opportunity every time in the court. That's why we requested your presence. Wait, you know, follow up in that. After, then after order, Mala. At about 3:45, we'll have to rise for some administrative work. After order, Mala. We will take up your upgrading. There are two matters to be upgraded. We'll take up this.
May I please, Your Lordship?
Yes.
Actually, in item number 11, I filed one affidavit in reply that may kindly be taken with record, Lordship. Sorry, I filed it around 12 o'clock. I got delayed, Lordship. Item number 11, Lordship.
But it will not come now. We'll give a date. Just wait for some time.
Lordship.
Item 24.
My lord, this case is ready, my lord, ready for hearing, my lord.
Okay. In fact, hearing date at Tuesday or Thursday. Tuesday, Thursdays or Saturday. Very convenient. We'll give a date. Item 24. Both sides are represented. No, just the appellant and the respondent one, and the state are represented. As the case is ready for hearing, this is the matter for hearing on this 2017 matter.
In the middle of July, my lord.
Middle of July.
Yeah,
right?
it will be convenient for me, otherwise.
What is it? 14 July?
16 July.
Yes, 16 July. Much. But this case is also ready, my lord.
For hearing. So for 2017. Hearing. 16 June. Both sides are represented. As the case is ready, is stated to be ready for hearing. This is the matter for hearing on 16/6/2026. Item 26. The last occasion, they had sought time to file an objection in the, but I don't think there is anyone appearing today. Just wait for some time, they will not be knowing they are upgrading it. Yes. Just wait for however. Yes. Please call, take it up in the second call. Item 27. Oh, you're there.
Oh, yes, sir. So, lot you are filing it today.
Find the objection.
Objection, Malab. In fact, I'll serving a copy right now and I'll file it today.
Okay. What says are represented, Mr. Rekalan, for the respondent number 1 and 2 submits that he is filing the objection in course of the day today. Accordingly, matter stands adjourned today. List again on, this is 21 of November. 3rd of June.
Highly obliged. After the second week, Malab is possible. Second week, Malab.
10, 6. GD Verma, government.
4 and 5.
Can it be on 12th, your lordship? 12, okay. 12. Highly obliged.
Item 27.
But on last occasion, I was directed to take steps, my lord. I could not take steps, my lord. Some time is run. In first week of June.
Okay, on the prayer made is by Mr. Abhishek Land, counsel for the applicants. Today's time is granted to the applicants to take steps for service of notice on the respondents by speed post to DD. The counsel for the applicant is permitted to collect the postal receipt number and to submit postal track report prior to the next date of listing. Okay, in the appeal also. In the appeal also, you have to take steps. My lord. On the prayer made by Mr. Abhishek Lal, counsel for the appellant, 2 days time is granted. The applicants to take steps for service of notice on the respondents by registered with speed post to DD. So, the counsel for the appellant is permitted to collect the postal receipt number and to submit postal track report prior to the next date of listing. Based on, they give a date, returnable date. Both the cases.
Obliged, your lordship.
Item 28.
May it please your lordship. Matter may be possible for the day, lordship.
Just a moment. You are taking a big risk of not taking steps, the petition would await against respondent numbers 2 to 9,
2 and 9.
2 and 9.
2 and 9. I am appearing
2
for
and 9.
2 and 9, and I am appearing for 1, 3, 3 to 8, 10 and 11.
Miss, what is the name?
P data.
Is P Dekan and counsel for the petition raised for adjournment? Mr. Safidi, learned counsel appears for responding numbers 1, 3, and 3 to 8,
3 to 8. And 10, 11.
comma 10 and 11.
Substitution petition has been filed by them, but it is not brought on record. I think that is in defect section.
File.
They are filed, but it is not brought on record. We have been having a copy of it.
The petition submits that. So, application for substitution of the bond and 9 was filed, but the stay is not on record. Next, accordingly, the registration. You've been served when? On which day you've been served?
We have received it on 16/10/25.
16/10/25. Even for the transfer for the respondent numbers 1, 3 to 8, 10 and 11 submits that he has been served with a copy of application for substitution of respondent numbers 2 to 9 is not on record. Next para. As per the office note dated 5/5/2026. Application, to look at the application for substitution and abatement in respect of respondent numbers 2 and 9 has not been received by the section. Stop. Next, according the then counsel for the petitioner, petitioner shall examine the same and do the full. Next para list. Give a date after a week. List on so and so. Yes, item 29.
Okay, please, Your Lord. So in item number 29, one has already appeared, also here appearing, but in respect of 2, 3, 4, and 5, I'll take fresh step also because notice has not been started.
The clear made by the counsel for the appellant. Today's time is granted to the appellant to take first steps for service of notice on respondent numbers 2 to 5. Next para, in view of the office note dated 13/5/2026, the Joint Council for the appellant shall take note of the same as it stated therein that the addressee is that in respect of respondent of 4.5, it has been stated that no such addressee is found as postal remark. Accordingly, the appellant shall ascertain as to whether the addresses of the respondent numbers 4 and 5 are proper, are correct and proper. Next part, in the event the addresses of the respondent numbers 4 and 5 are not correct, before taking steps, the address, their address is required to be brought on record in an appropriate manner. Time is given 2 days, huh? Make it 1 week. List one, give a returnable date after 5 weeks. Time. No, no. No, 5 weeks. Or after vacation needed.
17th of July. 17th of July.
Item 30,
I'm obliged. Some office note, my lord, regarding service.
Mr. Jeev Gill and counsel for the petitioner, petitioner. Next para. In your office note dated 15/5/2026, the petitioner shall take best steps within 3 working days for service of notice on the respondents by speed post in the area as well as by usual process to be routed through the jurisdictional civil court. Most of the concerned court was in charge of the Nazir branch shall direct the office that the service report is returned before the due date. Next, notice is made returnable on so and so, list accordingly.
Madam, I will take further some within 1 week, madam.
Okay, make it 1 week. Just a moment.
As regard to my lord, respondent number 6, 12, 15, 16, 18 to 20 is awaited right now.
And then it was registered post.
Yes, what do you say?
But so for office reminder, respondent number 6, 12, 15, 16, 18 to 20. Others I can take my lord fresh step. Whether I.
No, no, you see, this very, very cryptic. For example, sorry, not for example, the office note says AD card returned for respondent numbers 5, 8, 9, 10, 14, 17 with eligible signatures.
Yes,
There is no service at all.
yes, I can take fresh.
For others, 2, 4, 7, 13, 20, signed by Nazrul, who's not the respondent.
Yes, ma'am.
AD card for respondent 1 and 3 is signed by one Baharuddin, not a respondent. AD card for 11 is signed by Manawara Begum, not a respondent.
Yes, I can take fresh
And-
step, madam.
They were, everyone.
Rest one, my lord, rest 6, 12, 15, 16, 18.
They, for them, neither answered notice nor return, nor postal article has been returned.
Yes, ma'am.
Then
They have at a time.
they have to take. The last steps was taken in 9/12 to 2025.
So I'll
Even
take both.
tomorrow, if the service report comes, I will not accept it
Not good. So for all, madam.
for all.
All right.
31, or 31 is already adjourned, 32.
May I please refer to? As per office note dated 8/1/2026, service upon respondent number 2 is not complete. So I may be allowed to take 3 steps by way of dusting.
On the prayer made by land counsel for the petitioner, he is committed to take the appellant is permitted to take first steps for service of notice on respondent number 2 by speed post with AD as well as by usual process. None appears on call for the respondent number 1. Notice on the respondent number 2 is made returnable on so and so. The land counsel for the petitioner shall be at liberty to collect the postal receipt number and to submit postal track report prior to the next date of receipt. List on so and so. Item 33.
May please your lordship, yes. But as per the last order, no, PCA was called for, no. PCA is not available to them as well. To the person. Service has been completed, no.
I take respondent.
It's after. PCA.
Why do we need the LCR? Why do we need the LCR? This is a revision at Article 227. You will have to show us that the impugn order is liable to be interfered with. Yes. Why do you need this, LCR? We don't require an LCR.
Well, let's take this matter after some time. The senior is on next on court number 23. After some time.
You see, this is an abuse of the process of court. You call, senior will take it up.
Obligation.
We don't need the LCR. Possible. Item 34, 35.
Item 34 with item 35.
You think for early hearing the matter, liberty was granted by this honorable court on this, but
RSA 22 will not come for early hearing. What is the urgency?
the sale deed of the plaintiff has been declared to be invalid just because the boundaries were incorrect. There are some, our cases, the boundaries of the other person is incorrect, the defendant is incorrect, but the plaintiff's suit was allowed. That was reversed by the learned appellate court.
22 will cannot be, we will defer it for some time because now we are taking up hearing of 2009, 2010 second appeal.
I understand that. Also, we will keep it pending, we'll
That is-
deferred for some
we'll
time.
keep it deferred for some time because
Madam,
unless we make out a plan to hear the old pending cases, it will be very difficult. We're adjourning it for some time.
Madam.
Say both sides are represented. Yes. Interrogative application is for out of turn hearing. As the court is currently hearing the appeals which are ordering point of time, the clear made in this interrogative application is the hearing on these applications is deferred. Next again on due date in the after the vacation in July.
July.
Obliged, most of it.
Item 36.
May I please your lordship? Service is completed, your lordship. Kindly fix the matter for admission.
I guess allowing the amendment, but
Hmm?
allowing amendment. The cover for it.
June 166.
But why this objection? The hearing has not even begun. Why you are objecting to the amendment? The hearing has not started.
No.
Then how will you be prejudiced? I don't know, we have not heard on merit, but from the tenor of the order, it appears that has the council changed in the meantime? Same council is taken up.
In the here they have taken a new plea, that the defendant number one also said that they had trespassed this year in the part. And
But
that is why we have to.
no, but the tone and tenor of the order
Yes.
shows that the suit is defective in many ways.
Yes.
They are amending the foundational facts about the ownership, tenancy,
Yes.
possession,
Yes.
then court fees.
Okay. Okay.
That means almost a substitution of the entire plan.
Actually, because they have taken the plea that they are trespassers.
Hmm?
They, even number two, taken that they have trespassed into the point. And defendant number one said that they have trespassed. That is why we filed this, the amended complaint for eviction of defendant number one also.
No, but that stand pre-existed, the
Well,
filing of the plaint.
ah.
Therefore, we are asking that question, whether the lawyer has changed or he has suddenly become more
That I
wise.
do not know, my lord. That I do not know. Initially, the suit was for additional business.
You see, while we are asking you this question, you are prepared with the matter.
No, your lordship.
Okay. We'll take it up on Friday then. Let's say the represented on the prayer made by non-counsel for the petitioner, the matter stands adjourned today based on 29, 5/2026.
Master Plaza.
33,
Time being item 33.
I'm sorry, Milord, I could not hear.
yes. What was the date on which you filed the application for forensic examination?
Lordship, that is page 25, my lord. Petition, Annex 3.
No, no, not this. The earlier application to send it to forensic examination was when? That report came in 2019.
Yes,
So in 2019, you sent,
2019, initially, my lord.
that's what, in a suit, you file a forensic examination or document in 2019. In 2019, a report comes. Then you now in 2020, 2024,
Lord.
now you send it for forensic examination to find out the age of the ink.
Age. Yes, my lord.
Now you see, this can't be done. What is wrong in the order?
My lord. Your lordship,
Age of the ink.
yes, my lord, in this support, yes, my lord, in this support, my lord, and Honorable Apex Court on citation relied by the High Court,
That time to time you can send it for forensic examination of the same document.
my lord, that is the old document, in fact, my lord, discussed by the Honorable Apex Court in the Hyderabad High Court, my lord. The paragraph, my lord, 11, 16, 8, can my lord. Paragraph 11 and 16 to 18, my lord. This is Raja Lingalam with the Honorable Apex Court findings, my lord.
Paragraph numbers?
11, then, my lord, 16 to 18.
Yes.
And even petitioner is ready to bear the cost for this expert's opinion. What about the cost petitioner is ready to bear, my lord? And it is available only in, my lord, that is,
We'll tell you what. You take your own petition. This is your petition. Take it. I'm using the same logic which we are using now. Look at this. down below you will find written in backing is the signature and also word Hailakandi. You seen that?
Yes, my lord, Hailakandi.
Now, two different things. Now, should we send the matter to police for investigation? Who wrote this to? Your case is that the handnote is in a different handwriting and the signature is in a different handwriting. Is there a bar that says somebody else cannot write it and you can't sign it? You're not asking your signature for forensic examination. You're now wanting the age of the ink.
Because this petition is intended to cross the evidence of the.
So therefore, it's this is a plea to overcome the cross examination. In check bouncing cases, even I have authored orders where we have said that the check can be drawn in by somebody and signed by the person. So handwriting, there can be a difference. Even in my orders, you will find sometime difference. When I start putting signatures, the ink dries up in the pen. I notice it halfway of my signature.
That's true.
And then with the second pen, I sign it. Will it become illegal? If in middle of the signature, my ink goes dry, what will I do? I'll ask the 20 pages to be retyped again, just to match the color of the pen with the signatures. I don't do it.
And in fact, my lord, initially this London trial court was allowed to lord, but due to
We are showing it to you, whether we
Yes,
should now
yes.
send it to police to investigate, arrest the person, have the signature taken, how the difference in ink has come in the same page.
yes, ma'am. Understood, my lord.
No, it's impossible. This can't be the purpose of the court.
Please. Yeah. There are-
Sorry, we don't find, that's it.
I leave it up, lord.
You, in your case, there's nothing on record to show that you have taken a plea that my signatures in blank paper were used.
That is
Right.
not, my lord. That
That's
is-
not your
that
case.
is- No,
Then how can you lead evidence contrary to your pleading?
my case is, my lord, since, my lord, our application is considered by the London trial court, sir, due to not taking fair to take steps in time, our subject of prayer was not considered, my lord. They are so year before this court.
No, we can't encourage these things. Every day our judicial officers are under stress because the cases are not being disposed of. The prayers we make for bleeding can't be taken up because of the nature of board we have, and the trial court will cannot be burdened like that. Heard Mr. P.K. Dekal, counsel for the petitioner, also heard. You have appeared for?
I'm for responding.
Mr. Giudin, and counsel appears for the respondent. By this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 11/9/2025, passed by the learned civil judge within bracket junior division, bracket closed number 2, Hailakandi, in MS number 26 of 2020, by which this is paid 77, 77, by which in Manishwar Namasansa, whereby petition number 1781/10,
Yes.
was rejected.
Yes.
After lapse of the last chance. To take steps as directed by the court for sending the document for forensic examination. Full stop. The petitioner is also assailed the order dated 11/9/2025 passed by the said learned court rejecting the prayer for review of the order dated 17/7/2025. That's where the materials available on record reveals that the original suit was original suit by the petitioner. No, suit who is the plaintiff? By the respondent was registered as money suit number 14 of 2014. Subsequently, the case was transferred from the civil judge, Hailakandi, to the court of learned Munsif number 2, Hailakandi, and the suit was re-registered as MS 26 of 2020. Next paragraph. The then learned trial court, by order dated 31/5/2019, directed for an expert opinion from the Directorate of Forensic Science, Assam, Kailipara, and the said authority on forensic examination of the hand note, which was sent for examination, gave an opinion-wide report dated 6/5/2019. Thereafter, the case was fixed for cross-examination of PWs. It may be stated that the suit by the respondent is for recovery of money due under the hand note. Next paragraph. Sorry. Thereafter, on or about 21/9/2024, a petition was again filed by the petitioner defendant for sending the same document in respect of which earlier report dated 6/5/2019 was received. This time with a prayer to determine the age of the ink used. Full stop. The said order, the said petition was allowed by order dated 23/5/2025. And the petitioner defendant was directed to take immediate steps. The matter was then fixed on 26/2025. But the order passed on the said date is not brought on record. Next paragraph. It appears that on 17/7/2025, the petitioner had prayed for one last opportunity to take steps. The filing petition number 1781 of 2010. And the learned civil judge within bracket junior division, excuse number 2, Hailakandi, reject the application in view of the delay in taking steps. So as per the impugn order dated 17/7/2025, in the date in between, the petitioner defendant only filed a court attendance within oblique hajira without taking any steps. Next paragraph. Against the said order dated 17/7/2025, a review petition was filed, which was petition number 1867/05, dated 24/7/2025. It was rejected. The order dated 11/9/2025. Next paragraph. The learned counsel for the petitioner submitted that as the prayer for sending the document for forensic examination was allowed, merely for the delay in taking steps from a said opportunity could not have been taken away by the learned trial court. So it is stated that the petitioner defendant had disputed the signature, and as the writing in the hand note and the signature were by different things, there was reasonable doubt to be clarified by way of forensic examination of the record. So stop. In support of his submissions, reliance is placed on the decision of the Hyderabad High Court in the case of nominee Audi Shishya versus Numru Mohan Rao, AIR online 2018, Hyderabad HYD, Hyderabad 243. So it is submitted that in place this is grants on paragraph 11 and 16 to 18, which is based on the discussion made by the Supreme Court of India in the case of Shashi Kumar Banerjee, SASHI, Shashi Kumar Banerjee versus Subodh Kumar Banerjee. Next paragraph. In the present case in hand, the same document was already sent for forensic examination, and the report, the opinion report dated 6/5/2019, sent by the Directorate of Forensic Science, Assam, Kailipara at Gauhati, was already available. Full stop. From the contents of the order dated, from the petition number 414/03, it is, the court is inclined to note that in paragraph 2 of the said petition, the petitioner defendant has admitted that the suit was adjourned on many dates, and that both parties completed their evidence and cross-examination, and the suit was fixed for argument. Full stop. Thereafter, at the stage of argument, by filing petition number 414/03, the petitioner defendant is seeking to determine the age of the ink. Next paragraph. In the copy of the written statement of the defendant, of the petitioner defendant available on record, the handwriting and signature, the handwriting or the age of the ink was never disputed. And in paragraph 6 thereof, it was stated that the signature contained in the head note was disputed. And in that regard, a report of the forensic science laboratory is already available. Full stop. Therefore, the determination, therefore, the considered opinion of the court, the question of determination of age of ink would not be would not support the pleadings on record, as it is not the pleaded case of the petitioner defendant in the written statement that the signature was obtained in a blank piece of paper and subsequently filled up. In this case, the petitioner defendant had denied his signature. Therefore, the evidence sought to be introduced on the age of the ink is beyond pleadings. Next paragraph. The decision of the in the case of Nameni Audi Isha Suka would not be cannot be applied in the present case in hand, because in the present case the document was already sent, the disputed document, i.e., the handout was already sent for forensic examination, and the report had come on board by opinion dated 6/9/2019, 6/5/2019. The said decision is not an authority on the point that the same set of document can be repeatedly sent for forensic examination for one reason or the other. So this, in accordance with the considered opinion of the court, would make the exercise of determination of fact endless. As the same document cannot be repeatedly sent for forensic examination for different reasons in different point of time. Next, the court is conscious of the fact that the court is making this determination under Article 227 of the Constitution of India, and therefore the court is only inclined to see if the order suffers from any perversity. In this case, the learned trial court has already rejected the application, and therefore, to that extent, the court does not find any conformity with the said order. There is no conformity. So, for the remarks with regard to the tenability of the sending of the same document for a forensic examination is only a collateral determination. As it appeared to the court that the ink of the document was not a facting issue and not really required to be determined by the learned trial court when the evidence is already closed and the case is fixed for argument. Next, accordingly, having found no merit in the application, the same is dismissed. Next paragraph, as both sides are represented to the learned counsel, both sides are directed to appear before the learned civil judge in bracket junior division number 2, Hailakandi. Just complete, let me complete. Yeah, Hailakandi on 12/6/2026. Next paragraph. As the division is dismissed from the interim order passed
to 26 minutes.
on 2/2/2026. Gets merged with this order.
That's one.
All right. But item 37.
On the last occasion, your lordship asked these to issue notice, but due to an evident error from our side, we couldn't take steps.
How will a revision lie? And Article 227 when there is no appeal provided for. Mr. Goyal is there? No. And you have not taken steps?
Due to an inherent error. Due to an inherent error on our side. The lordship may be granting us time till tomorrow, we'll take steps.
Okay. On the prayer made by learned counsel for the petitioner, one last chance of 2 days is granted to the petitioner to take steps for service of notice of the respondents. Next paragraph. The next day, the party shall also address the court as regards the maintainability of the challenge made in this application. The, before that, we said the notice is made returnable on so and so. The Learned Counsel for the petitioner is at liberty to collect the postal receipt number and to submit postal tax report prior to the name of the thing. List of so and so. 38.
The office note dated 21/5/2026, reflects that neither AD nor unserved notice has come. Now, my prayer,
Taken steps when?
steps were taken after, immediately after the passing of the order. I don't have the text, the date.
25/3.
Well, and the address that we have taken steps on, that address is provided by the respondent in various petitions that have been filed in which are next year also. So my prayer, my lord, order 5, rule 9, sub rule 5 provides, so perhaps can be invoked.
No, because you are also directed to take usual steps, which you are
No,
not
my lord,
taken.
there is no direction. Your lordship sees the first order, there is an office note, but there is no such direction in the order that was passed. It was only for speech.
Okay, then you take up the steps.
Well,
Mr. D. Chakravarti, Learned Counsel for the petitioner, as is
you are appearing. You are appearing. My lord, my friend is appearing in this case, it seems, for the.
Oh, you have here. Yes.
1 to 5, lordship.
No, there is only one respondent.
Hmm?
This is not the 9. No, in 30. 30. For a while, I was relaxed. I was relaxed for a while.
Mr. D. Chakravarti, Learned Counsel for the petitioner is present. Next para. As the neither the AD card nor the postal article has been returned, the court is inclined to direct the petitioner to take first steps for service of notice on the respondent by speed post with AD. Next para, the Learned Counsel for the petitioner shall collect the postal receipt number and to submit postal tax report prior to the next date of listing. The notice is made returnable on so and so, list on so and so. This time give a postal tax report.
Well, it has only directed for speed post.
Speed post.
Okay.
39.
Mr. Chaudhary was here. But Mr. G. Chaudhary, Learned Counsel for the petitioner, as per in view of the office note dated 21/5/2026, 2 days time is granted to the petitioner to take steps for service of notice on the respondents by speed post with AD. Next, for the Learned Counsel for the petitioner shall collect the postal receipt number and to submit postal tax report prior to the next date of listing. Notice is made returnable on so and so, list on so and so. Item 40,
This IA is seeking direction for payment of maintenance which was stopped because of the stay order. There is a stay order of this honorable court, the proceeding of the trial. The stay order does not have anything to do with the maintenance. Our maintenance is stopped.
Lordship, we have some objection, we will file our objection, Lordship.
Yeah,
In fact,
Lordship will-
accommodation may be.
just a moment.
There is, this maintenance order is not subject matter of the revision petition also. Order of this honorable court, you will find at page,
No,
10.
no, that's not something I have not been able to follow. Why the prayer in the main revision should not be allowed? This is a matrimonial proceedings.
Yes, my lord, but
The respondent petitioner appeared through a amicus curiae.
yes. However, in the application, but they didn't, nowhere they gave the names of the witnesses.
It's an amicus curiae. What can you say?
But in the application also, my lord, the application that
We understand there may not be a communication. The amicus curiae gives a petition and then they don't follow up. Amicus curiae is appearing for the wife or for the husband.
yes, husband is the petitioner.
It is
I'm for the respondent here. So, the application is at page 15, my lord.
the plaintiff is the
PW, after PW is.
no, who is the plaintiff?
My lord, plaintiff
Who
is
is
the
the petitioner?
husband.
Huh?
Plaintiff is the husband, who is
Husband.
the revision petitioner here.
Okay. And who is for the husband? You are for the husband.
No, no.
You are
I'm
for
for
the,
the
you are for
wife.
the husband.
Yes.
Then amicus curiae is for the wife.
Yes, my lord. Your lordship will see that in the application before the trial court, they say it at paragraph 2, my lord. The petitioner earlier stated before his engaged advocate should so and so. So that is engaged advocate. And this is the only ground they are seeking. After examining two witnesses, they expressly declined to examine any further evidence, my lord. And then two defense witnesses were examined. At that
Yes,
stage,
are you seriously contesting it?
Lordship,
Are you seriously contesting that petition?
Lordship. Lordship, we are filing our objection, Lordship. Sometime maybe it's required, Lordship.
You are filing your objection.
but how can how can an objection be there, my lord? This maintenance order is not under telling. It is not subject matter of the revision petition, my lord. I filed the IA because
You forget about the IA. What is the prayer in your petition? She will be filing an objection in your revision petition, not in this
no,
IA.
she is the revision petitioner, my lord. She is representing the petitioner, revision petitioner.
Petitioner is the husband
Yes,
and you are the wife.
I am the
So
one.
then we reverse the question, we are putting it to you. Are you seriously contesting that application? What is so bad about it? One chance in a family court to adduce
Because
evidence.
the trial court order, there is no infirmity there, my lord. It is legally sound order. There is no ground. The only ground is the negligence of attributed negligence of the counsel. And also the application doesn't reveal which witnesses and how they are necessary. Nothing about that. Who would be examined, on what points they would be
It's
examined.
a family dispute, what they can examine. How will it, you will suffer any prejudice? The time which is lost by keeping this matter pending for 1 year, at that time your matrimonial suit would have been over.
But at this stage, my lord, they have to show that these witnesses are essential for the just decision of the case, my lord. There is nothing about that.
And you are proposing to file your objection where?
Lordship, in the IA,
In the IA.
Lordship.
You see, this is the order of maintenance,
Yes,
7,500.
yes, for the children, my.
If you don't make payment, how will the wife maintain herself?
Regarding that, Lordship.
You pay a maintenance cost of the litigation cost 25,000. You pay deposit before the register of this court if you want to contest this.
Yes, Lordship. I have instruction from my senior, Lordship.
It's not required. We allow this application. The maintenance was never stayed.
Never stayed.
Only the further proceeding was stayed.
Yes,
How can it stop the maintenance? we'll take it up next week. In the meantime, if you contest the proceedings, although there was no stay, then you'll have to deposit litigation cost of 25,000 for the wife.
Sometime maybe granted the.
We'll give you next day. You want to consult your senior, you do it. But we are posting it next week. And the condition is that if you are contesting the matter, then you'll have to deposit 25,000 as cost of litigation for the wife. Mr. Laskar would not be, has to be duly compensated. Cost of litigation. IA, but Mr. Laskar done cost for the applicant. Miss
And Bora Lordship on behalf of SP Chaudhary.
M. Bora, learned counsel, appears on behalf of Mr. SP Chaudhary, learned counsel for the respondent. Who is the petitioner in the connected TRPIO 371 of 2025, raised for and is granted 1 week's time to file objection, if any, to the application. Next para. It is provided that as the applicant has disclosed that she has 2 minor children as well as a younger son of tender age, the court is inclined to put the respondent to notice as to why a cost of litigation as the maintenance has been not deposited, why litigation cost of rupees 25,000 shall not be imposed on the respondent to be paid to the applicant. This is the matter on 3/6/2026. Objection, if any, we filed at least 1 day prior to the next date of listing.
Lordship interim order.
What is the next date? What do you call the interim order is still when?
Interim order is not related to interim.
It is still further orders. Sir, then if you are asking for stay of the interim order, we also say that as the stay of proceedings may not construe as a waiver of payment of maintenance, the petitioner shall appear on the next date of listing along with the 1 month's monthly maintenance to be deposited as per the directions of the court on the next date of listing. Next list on 3/6/2026. So next date you will be also bringing 7,500 as maintenance cost. Apart from this 25,000, you also bring the 7,500, which will be deposited as per the directions which are to be passed by the court on the that date. 25,000 is the cost of litigation and 7,500 is the maintenance cost. We'll take it here in the court. Forty-one.
I would say of the interim judgment and decree dated 25/11/2025. Appeal has already been admitted, Your Honor.
Has been admitted.
Yes, Your Honor.
Where is the which is the order in appeal?
27/3/2026.
Which page? Which page of the memo is that order? First appellate order.
Oh,
page 17 in the memo of the page.
17.
Yes, correct.
Who is the plaintiff?
They are the plaintiff. Respondent 1 and 2.
You are the plaintiff.
No, you're,
You're the plaintiff.
I
And
was-
you are?
I'm the counterclaimant, defendant counterclaimant, number 5.
Counterclaim was dismissed and the suit was decreed.
No, Your Honor, the suit was dismissed and counterclaim was allowed. Subsequently, that appellate court reversed the
That's
finding.
what we are asking. When we are reading the appellate court, that's what we are asking. Counterclaim was dismissed
Yes, sir.
and the suit was allowed.
Yes.
Now, what do you fear in execution?
Lordship, the mutation entries. The sale deed has been cancelled.
After sale deed is cancelled, how will a mutation take place?
It was done previously. It was done previously. Now the court has said that the sale deed is cancelled and the mutation entries to be cancelled.
Okay. Cancellation of mutation, where is that part?
Page 66, Your Honor. Of my
Entitled declaration that the impugn sale deed is vitiated for once of free consent and cancelled.
no, Your Honor. Page 66 of my IA, Your Honor.
Page
66,
your IA.
66 of the IA. May I read you?
Okay. You state
We will maintain status.
your name,
M. Bedia.
M.
Bedia.
Mr. M. Berial, and counsel for the applicant, and also heard Mr.
A. Dhanukar.
A.
Dhanukar. Dhanukar.
A. Dhanukar, and counsel for the respondent. Number
One
you for respondent were 1 and 2, and state is there. You for the state?
4 and 6.
4 and 6. Your name? Ms. M. Kalita, and you're the government advocate? Government advocate appears for respondent numbers 4 and 6. And who will appear for 3? Revenue?
Government advocate is,
Revenue department who is there? Barpujari. Barpujari. Who will appear for the revenue department? Barpujari or J. Hendik? J. Hendik. And Mr. J. Hendik, standing also for the revenue department, appearing for number 3. 3-1. If you are the government advocate, you will also appear for 3-2. 3-2 also. Municipal administration. Who's there? You can appear. And Mr. Your name I forgot. No, it's okay. Your name is get it. Mr. D.R. Gogel, and government advocate appearing for respond number 3 within bracket Roman 2. By filing this interlocutory application under order 41 rule 5, read with section 151 CPC, comma, the applicant who is the appellant in the connected RSA 23 of 2026 has paid for stay of the execution of the impugned judgment and decree dated 11 5/2025, passed by the Learned Civil Judge within bracket Senior Division, bracket closed. Sonipur, comma, Tejpur in TA number 13 of 2024. Next, as the connected appeal has been admitted for a hearing by order dated 27/3/2026 on substantial questions of law as framed hearing, comma, the court is of the considered opinion that in the event the decree is executed, comma, it may prejudice the applicant. So accordingly, comma, the execution of the judgment and decree dated 25/11/2025 passed by the Learned Civil Judge in bracket Senior Division, bracket Sonipur, comma, Tejpur in TA 13 of 2024 is stayed. Next para. Who is the plaintiffs? You are the plaintiff. Mr. However, comma, this order does not stand in the way of the declaration given by the learned First Appellate Court that the plaintiffs are in possession of the suit land. And the as well as the permanent injunction restraining the defendant number 5 within bracket appellant in RSA 23 or 2026 from entering into or disturbing the possession of the plaintiff on the suit land or house should land and house. So this order will not,
So we are not going to disturb the position.
no, that's okay, but this protection to the possession is maintained.
Yes.
And injunction is maintained. Next para. Next to saying this ice and this disposed of. And
Also, this will also not create third party interest versus. Status quo should be maintained by both the parties.
that you'll have to make a prayer. 3, 1, 3, 2, and 5. Who is 3, 1, 3, 2, and 5? Three, 1, 3, 2, and 5. In the main appeal, you say, heard the real counsel for the appellant, Mr. Dhanuka, for the respondent numbers 1 and 2. Mr. Bogoit for respondent number 3, 1. And she will go 3, 2. Three, 2, 3, 4, and 3, 6. Oh, no. 1, 3, 1 will be Mr. Hendick. 3, 2 will be Mr. Gogoi. She will be for 4 and 6. Next one, as the requisite extra copies of the memo appeal be furnished to the learned government advocate and the learned standing counsel for respondent numbers 1 and 2 within 2 days. Next, the appellant shall take first steps for service of notice on respondent number 5 by speed post with the D, the learned counsel for the appellant shall collect the postal receipt number and to submit postal track report prior to the next date of listing. Next para. The receipt of records is awaited. Next para, the notice to respond 5 is made returnable on so and so. List on so and so. On number 5, we'll have to take first steps.
Much obliged.
Mr. Sheikh, which is your matter? You wanted an upgrading? Other matters will have to be adjourned because I'll have to write that 3:45 is a meeting. Okay, in 11, Mr. A. Bhattacharya, and counsel for the petitioner. So for he submits that the affidavit
in reply, we have
in reply by the petitioner has been filed. This was the registry and tagged with the record. List again on 29.
25th, Lordship, 25th June.
You wanted long,
Because Lordship, I have one surgery schedule, Lordship. I have some personal difficulty also.
Okay, we take it 24th or 26th?
24th to 25th.
24th.
Interim may continue till then, Lordship.
Interim order passed for list and extended till the next bit of listing.
Deployment.
Yes.
24th.
Yes, yes, Yes,
Wait, please, Your Lordship. My lord, actually background of the case is this, that the plaintiff, my lord, filed a suit. And here it is said that he is the owner of a plot of land measuring three katha 17 lesser. But from reading of the plaint, my lord, your lordship will get what is
Mr.
the
Sheikh.
source of,
Mr. Sheikh,
my lord,
please come to page 4 of your memo of appeal.
4. Yes, my lord,
All of these are questions of fact.
my lord.
There's no substantial question of law here. None of the 8 points you have raised here.
No, my lord, my humble submission before your lordship, I have framed one issue, my lord, substantial question law. Recorded as period Patadak should not without any earlier source of right of title. My lord, your lordship would be pleased to see at 2.
There's a question of fact.
No, my lord, your lordship, my humble submission before your lordship, that if somebody do not have source of right, then how he will get the degree?
No, that we don't know because you see, the manner in which I understand
My lord.
is a bit different. You see, the name in the pata,
My lord,
if it is incorrect,
my lord.
please come to the, please come to this the copy of the plaint,
My lord,
which you have annexed.
my lord.
Please come to,
Plaint, my lord, it
Yes.
is from 21,
page 23 is the prayer.
23.
Yes. So you see, there is no dispute with regard to title.
My lord,
Here, A, B, C declaring right title interest for extinguishing of the title of the so-called person whose name is illegally entered in the pata.
my lord, thing is this, my lord, we were not defendants there.
Hmm?
We are not made defendants there. But what happened, my lord, after the decree, we filed a petition. We filed a petition under Order 21, my lord, Rule 99, claiming that it is our property we inherited from our father.
Yes.
That was the petition, my lord. That petition, after decree we filed. We were not party before the court.
Okay.
Only in the original suit, my lord. So that is why, my lord, we did not have any
The
option.
same thing again, you come to page 47,
My lord,
come to page 47.
47.
Declares that the judgment and order is not binding,
My lord.
they cannot be evicted. And to confirm their position. So your right title and interest was not even claimed here.
Decree dated 18/2/2015 in respect of judgment and order dated so and so
It's not binding.
is not binding on the petitioner.
But you don't claim title here.
If we are the petitioners, my lord, if this is not binding on us, that is why, my lord, if the decree is executed, then we'll be evicted from the land.
That's what we are
My lord.
asking you,
My
Mr.
lord.
Sheikh. That is
My
the
lord.
fair.
My lord.
That means the title was never any dispute.
My lord. I could not follow, my lord.
If that is the fair, that means the title of the person whom you are trying to extinguish
My lord.
is not in a defense taken in your, the application in the order 21/99
My lord.
or read with section 47.
My lord.
Now therefore, please come to this order of 2018. This is how it was given.
2018, my lord.
Yes, that is the order, page 51.
Yes.
Is your, no, sorry, not this. Where is the first appellate?
So, my lord, the petition in 2018, it was dismissed, my lord.
Hmm.
Against that, we filed a title suit, title appeal.
The title appeal.
In the title appeal, my lord, it was remanded back.
Yes.
And after remand, my lord, that was looked into by the court below, my lord, and it was registered as
That
this
is-
case 29. So, my
This
lord,
case
thereafter
29.
what? Thereafter,
No,
the
no, page
impugned
51
judgment
is
was-
what order?
My lord,
Page 51 is what order?
Page 51 is the order. Against that order, my lord, we filed a title appeal. And matter was remanded back. And thereafter, my lord, this landed court below, my lord, in title appeal. That was taken into consideration, my lord, that was registered as Midje case. And that was disposed of, my lord, dismissing the Midje case. After that, my lord, that Midje case, we filed an appeal before the senior civil judge senior division. And senior division, my lord, again in title appeal, dismissed our, that was upheld matter. That is the position of the case. So, my lord, our entire case is this, my lord. The property in question is inherited property of the appellants, my lord.
No, please come to page 51, that's.
Yes, 51.
Yes,
Yes, my lord.
page 51 says,
No.
the operative paragraph. The petition was filed by Mohammed Jinanur Ali and Mohammed so-and-so, under so-and-so. It is stated that they were the owner and possessor of the land,
My lord.
measuring 2 biga 1 kata 3 lacha covered by dag number so-and-so. The opposite party, Wazatuddin, in collusion with the revenue staff, mutated his name in AP so-and-so, and also converted so-and-so periodic patta
My lord.
by creating new dag without their knowledge. Wazatuddin obtained a decree without impeding the petitioners. Correct.
Hey, my lord.
Now, you come to next page, page 52.
My lord.
Now, here you say that you are the, you contended that you are the owner and co-pattadar of the land.
My lord.
Correct.
Yes, my lord.
Now, this, so far as the earlier page is concerned,
My lord.
we will take it tomorrow because the meeting has already started.
My lord. My lord.
This is tomorrow. You see, I'll tell you, in this page 51 order, you did not, what you call, although you claim to be in possession, but you don't assert your title.
My lord.
And therefore, when the issue was taken up, you also took a plea there that there was a collusive entry in the record of rights. To that effect, we don't find anything that there is any attempt to prove or disprove this.
My lord.
And under order 21 to 97, any question has to be adjudicated like a suit. Therefore, and that would be a decree.
Yeah.
How can, with no evidence read and nothing on record to show?
My lord, I have given evidence, my lord.
But it is not affected, your evidence about
My
your
lord,
title is not.
here, my lord, before evidence, this order has been passed. Your lordship would be pleased to see the.
We'll take it up tomorrow.
Oh, yes,
Be
my lord.
prepared. That is the only point.
My lord, I-
Don't find that there is certain question.
I will see, my lord.
You want to say something?
There are 18 numbers in the daily list.
Those are or not?
Yes, I know, my lord. May I request, my lord, to fix it on 11th of June? Yes. 10th, I will come, 11th, I will be there. If it is possible.
That is a hearing day.
Hearing time. It's a order 41 rule 11 hearing.
My lord, I'm to mention it again.